Okay, so welcome to the work session of the Southampton Village Zoning Board of Appeals, February 16th, 2021. We welcome to the meeting our new counsel to the Zoning Board of Appeals, Jeffrey Blinkoff.
Good evening.
Thank
all.
you, Jeffrey. Of
Good evening. Thank you so
Good
much.
evening, Jeffrey.
Mark, before we go on, I have a question.
course.
What is going on in this village? This is our third attorney in 3 years, three village attorneys in less than 2 years, sorry, three village attorneys in less than 2 years. Something is rotten somewhere. Something's going wrong. We had the same attorney for 30 years.
I remember Rick DePetris.
30 years we had him. You get stability that way. You get comfortable with each other. Now we have somebody brand new. Who knows how long he's going to stay?
Well,
Average about 8 months. So if he beats 8 months, I guess he's a long timer. I mean, this is ridiculous. Does anybody know what's going on?
well, I can't answer that.
That means that you know, but you can't answer it?
No, it means I don't know.
You don't know.
I would tell you if I knew.
All right. Something's wrong somewhere. It just can't go on like this. I don't know what's going to happen.
I think we were spoiled having Rick for such a long time. I thought he was a great counsel.
It's fantastic. And we just get used to David, and now he's gone.
Mm-hmm.
There's got to be some reason why these attorneys, why they keep resigning. I don't know what it is, but there's got to be one.
I can't speak to that, sir, but I hope to be able to serve you well, and I'm certainly available to speak with you at any time, and hopefully you'll be comfortable with me. But I've just come on board, so I'm pleased to meet you, and I hope that we'll be able to work together well.
We'll get comfortable with you, and then you'll resign.
No, well, Kevin, let's give Jeffrey a warmer welcome than that.
Oh, that's what the facts say. That's what the facts of the last less than 2 years say.
Mm-hmm. Okay, so why don't we start with we have a pending decision, Apogee Building Company LLC, 10 Center Street. But I think we're awaiting a revised survey to show that the pool location will be at the same distance from the southern border of the property as the house, but we have not seen that yet, so we're going to await receipt of that revised survey.
Okay.
And then we have case number 3100, Barbara Reuter and William Williams, 599 Meadow Lane. Chick, do you want to speak to that?
Sure. I'm sure you all remember that is this small catwalk that they're proposing north on a parcel off of Meadow Lane into Shinnecock Bay. They have open grate decking. We talked in detail at the last meeting about how they avoided trees on the land, avoided trees near the property line to the north, that it's a minimal structure, that it helps to prevent trampling of the wetlands. And they, in their presentation, the applicant actually said that that's what they've done in the past. So I would expect the wetlands to rebound and be healthier. And I don't recall, at least I checked my notes, that I didn't see that I was directed to prepare a decision, but I don't believe there are any outstanding questions. So depending on your input to me tonight, I can certainly have a decision for the meeting next Thursday.
Have you visited, Chick, the property?
Yes.
Does anybody on the board have any questions?
No, I thought they did a good job,
It's a cakewalk.
and Chick did too, but I thought it,
Dan, if
they
you didn't hear him,
listened,
says
they
he's
told
fine
us the
with it.
things we needed to know.
Thank you very much. And I'll just take this moment to say hello, Jeffrey. Jim Voorhees. I've been with the zoning board since 2006, and hope I serve the board well also. But I really am just here for wetlands because the village has their own wetlands law under Chapter 116, and we issue wetland special permits. So to the extent that there are variances and other zoning board matters that don't involve wetlands, I'm really not involved. Sometimes I'm requested to provide input on seeker administration on special projects before the zoning board. None of those are pending now, and actually, there's really only 3 wetlands matters pending right now before the zoning board. One of them is adjourned, and one is a new project. So just a little background, I've been an environmental planning consultant for 43 years on Long Island. I'm amazed that we have not worked together yet, but I welcome this opportunity to work with you.
Same here. Good to meet you, sir.
Thank you.
So yes, Chick, you can go ahead and prepare your permit
Your
for case number 3100.
Yes, your permit. I'll have that in by Tuesday, and I don't expect any issues.
Okay, so we can move on to pending cases. Case number 3087, 71 Walnut Street. This is a case requesting 4 separate variances. We received additional materials from counsel for the applicant, Gil Flanagan. And the board has been deliberating this case for some time. It seems right now that the board's inclination is to grant 3 of the 4 variances. The variance for the addition to the southern front yard setback of 11.3 feet. The variance for the addition to the north side of the dwelling. And the variance for the 484 square foot detached garage, but is reluctant to issue a variance for the hot tub. So knowing that, the applicant will present at the next public hearing. Does
Mark,
the board have any comments?
do we have a survey that shows the reduced garage size? I don't. I have one, let me just see. 1/29/2021, is that the most recent?
Yes,
Is that the right one? Because that looks like the garage is bigger than I thought. Can anybody help me?
Well, I'm looking for the cover letter that I do have this, the latest survey that was submitted. And
Right, I have a cover letter. It was dated February 10th. It's so long, God. Cut to the-
I have Lisa Zaloga's summary from February 8.
Where's that?
That is a ZBA request comparison from 19 to 21 between the porch, the south entry addition, the garage pool house.
February,
That's February 8th, 2021.
so I have,
And it came with a letter that's dated February 9, 2021.
wait. This says, accordingly, request is hereby made that such application be adjourned for all purposes to your meeting in March. The
no,
letter-
that's the other case.
Oh,
That's 1384 Meadow Lane.
that's Four Fountains. Okay, good. So I don't see the survey. So the survey I have dated the 21st shows a car and then storage and 2 cars parked behind on an apron. Is that what we're talking about?
That's what I have.
Yeah, but isn't his, doesn't is that the much reduced size or not? Let's
I
see.
thought that was the survey where the doors are changed so that they're not glass doors.
Do we have I just feel like we need to have a survey it shows those things,
Mhm.
the reduced size and that there's not glass in the doors and a few other things. But I don't
Agreed.
know, this is attached. I have January 29th, 2021, then I've got February 9th, okay. So on this, I don't see a survey on the February 9th.
Correct. There's a letter from Lisa Zaloga on the 9th, and there is the variance applications comparison that's dated February 8th.
But to Susan's point, I have Lisa Zaloga's site plan, but not a survey.
Correct.
Okay, so we can request that of the applicant.
If it's required, we've got it, you can't. I mean, we want to be certain about what we're saying yes to, no?
Of course.
And that's the part that I didn't quite get.
Chair, I have 4 attendees' hands up. I know it's a work session, so would you like me to tell you whose hands up, or you just want to wait until the public hearing?
No, we don't have to wait. Whose hand is up?
I have John Wops, excuse me if I'm saying that wrong, Lisa Zaluga, Rosemary Renna, and Gilbert Flanagan.
Does the board have any additional comments, or do we want to hear from John and the applicant?
I have nothing to add at this time.
I would only want to hear something new.
Okay, well, let's hear from the neighbor. I think it was John.
John?
Can you let John?
Absolutely. I'm going to move him over. Okay, John, I just need you to unmute yourself and turn your camera on, please. John, could we have you unmute yourself and turn your camera on, please?
Can you hear me?
Yes.
Yep.
Okay. Can you see me?
We cannot.
Can't see you, we hear you.
How do I, this is all new to me. I'm sorry.
On the bottom of your screen, it will, next to the mute button, you're going to hit where it says stop video. If you unclick it, it will
Oh,
start.
hit plus?
If it's okay with the board, if the sound's all right, then
Hang on a second. I'm trying.
okay.
On the bottom right?
The bottom left, excuse me.
Or
Next
bottom left?
right next to the mute button, it should say stop or start video.
I don't see that. I'm on a very small screen.
Okay.
I cannot find that. I'm sorry.
I'm sure the board, are you okay with him not having his camera on? Okay.
Fine, yeah.
Okay.
You can hear me, correct?
Yep.
Okay, so I cannot see the board any longer.
That's probably because you're on your, are you on your phone?
No, I'm on a tablet.
Okay. I'm not quite sure. Possibly you might want to try up at the top where it says speaker view. If you click gallery view, you might be able to see the board. But
Okay, hang on a second. Thank you for helping me. I appreciate it.
I'm trying.
I'm not computer literate. Mute. Hang on a second. It keeps going away. One more second. Thank you.
Okay.
No, that's not it. I'm pushing all the buttons. Oh, participant.
Nope, it wouldn't be that. It's all the way up on the right. But I don't think it matters. They can hear you. I think.
Okay.
Yeah.
Okay. All right. First, I'd like to make a statement. I wish I could see the board. And I cannot. Okay.
Sorry about that.
And
First,
we
I'd like
wish
to
we
make a
could see you.
First thing I'd like to say, instead of dragging this thing out, I agree with Kevin wholeheartedly about the lawyers. I played ping pong with the Petras boys, the twins, when they were kids. That's how far back I go. Do you hear me, Kevin?
I hear you, John.
Thank you. And Daniel, you got to stop playing with the computers. You're not of the age of computer literacy. And that's your problem. You hear me, Dan?
I hear you.
Attaboy. So anyway, this has been going on for a long time. And I really cannot add much more except a few things I'd like to bring to the board's attention. It seems like this is like throwing as many mud balls to the wall as you can and see which ones stick. The applicant has been putting one thing after the next, and I like Gil Flanagan. I understand where he's coming from. Unfortunately, I just don't get some of the things she's trying to do. And one of the, well, several of them, but the first one I'm going to start with is the front addition on the south side of the house on Walnut Street. She's asking for an addition that's already in, the house is already in violation as far as the setback from the road. So I'm going to just take two steps back. I'm sorry, but to reminisce, 27 Rogers Avenue, the house Carol and I have owned for all our lives, and we've lived there all our lives. That house there, we asked for a 3-foot shelter over the top without any porch or anything, just so you could get in the door without the rain. And if you'll remember, I guess Kevin would remember, Dr. No, I think probably Dan might as well. Dr. Corman shot us down because we were taking, as it was put to us, we were taking the block out of line by putting something outside the line going forward into towards the street. That's the way it was explained to us. And I feel the same way today with this thing on 71 Walnut Street. I grew up directly across the street from that. I was born in 1945. I'm 76 years old, and I know that house backwards and forwards. I had friends that grew up in that house, and they never had a porch there. And they had, that was the front door for the, that was the door for the second story. It was never open to the living room as it is now. And when I'm having a problem with, it's throwing the block out of alignment. You're asking for already something that's in violation and adding the violation worse. As far as correcting the zoning, I think that's where you guys are in charge. And then the second thing is the, well, I don't mind so much the addition to the back, to the kitchen, and I can fully and appreciate that. But I don't like the fact that it's just, and I have to say, Dan, you saw nothing wrong with that when that was, when I listened to like 6 months ago, nothing wrong with that front addition. And I have to say once again, I was shot down for a 3-foot overhang just so I could get in without getting, wet and get into the house on 27 Rogers. So all of a sudden now we're going to put a 15-foot addition, 15 square foot, whatever it may be, and allow, and you're already in violation. And everything that this applicant is asking for is in violation. So my wife and I owned that house next door since 1968. We've lived there all our lives in Southampton Village, both of us. So I'm just asking you guys to take a hard look at these exceptions because they keep throwing mud at the wall. This has been going on, I think, almost 2 years now. And I might want to add something about, which was brought up at one meeting, about we have a basketball court in the back of 65 Walnut Street. That is not true. I put a parking lot in the back of 65 Walnut Street because I was told years ago that you could not park on a village street during the winter in a snowstorm. So when Carol and I purchased the home, we decided, which was against her judgment, to get rid of the green wall in the back, to put parking so they had all-street parking, which made perfect sense living in that to the village, close to the main street, so which we did. And then now it's being shoved up my backside for the fact that it's a basketball court. That's not true. A tenant upstairs decided to put one of those rollout basketball things out there, which came up in a minute, so you can take a look at it. And as soon as I found out about it, I had it removed because they were not allowed to do that. That's not in his lease. That's not supposed to be there. So that went away. And the other thing I want to bring up is about the neighbor next door on, I can't remember the number, but it'd be the neighbor right to the west of me, Steve. No. When he sent a letter of approval for this tenant, for this applicant, for all these things that she wanted to do, but you might want to note that he has since is selling his house. He's in contract. He's in contract. His house is totally vacant. There's no furniture. And he did this on spite for me. So once again, this is like really bothering us to no end. We've lived there all our lives. And I think this person that's this applicant that's trying to do these things is just pushing the envelope of your board. And I wish you'd give a lot more attention to what she's asking for. And that's all I have to say. I'm sorry for being so windy.
No, thank you for your input.
Okay, and the other hands are up. You want to wait until the public hearing for those, right?
No, who wants to speak on behalf of the applicant?
Same people. We have Lisa Zaluga, Rosemary Renna, and Gilbert Flanagan.
Do they want to pick who wants to address the applicant's interests? Do you want to ask Gil?
I can't speak to him unless I promote him. Oh,
Go ahead, promote Gil.
Okay. Okay, Gil, we have you here. I just need you to unmute and camera on, please.
Okay, did that work?
Yep. You're on.
Everybody hear me?
Yep.
Okay. I don't intend to offer a lot that's new, but one thing I do want to say about the survey and the site plan and so forth, the site plan was submitted dated January 29th. It's certified by the architect, and as you probably know from the decades some of you have been doing this, that it's quite common to accept an architect's site plan for improvements which are based on a survey, which this one was. And again, what we submitted was signed and sealed by the architect. So in the past, that's always been sufficient. If you wanted the survey updated to show the same thing, I'm sure we could do that. But suffice it to say that is sufficient.
Gil, we were as concerned, or frankly more concerned about having the most recent site plan. Which is the most recent? How do I identify that?
January 29th. In fact, I submitted a letter when we wanted to renotice it, a letter dated January 29th, and the site plan accompanied that letter, which specified the relief. So that's
Okay.
the one you should be working with, and I have a copy of it here. So
No, so do I. We just want to be all on the same page.
yep, yeah, that's the one. Now I know I'm going to have an opportunity next week to say a few things, but I think we have to start off with the fact that what you can do, and I'm sure your counsel will tell you, is governed in large part by New York State enabling legislation contained in Village Law Section 7-712 little b. And as I've mentioned before, that involves a balancing test which weighs the benefits to the applicant against any negative effect on the neighborhood or the environment. And I think from what we have shown, there are essentially no negative effects on the environment or the neighborhood. In fact, as we pointed out before, the majority of lots and improvements in this entire block are non-conforming. So the fact that this building is non-conforming shouldn't be a basis to single it out for worse treatment than anybody else. Second of all, as we pointed out, there will be some environmental benefits from this application, from the grant of these variances, by the installation of a new sanitary system, by the elimination of a second dwelling unit if the application is granted, and screening is necessary. So it's important to remember what the state has given you the power to do and what you should be looking at. It's not a question of whether or not somebody likes it or not. It's a question of when you do the balancing test, where do you come out? I have not heard through any of these meetings, as the application has been modified to address concerns, that there is any remaining negative impact on the community. Now, John Wopes, that early on when we first started this, had a concern about the addition to the north of the house and the fact that it was flat and he didn't want a roof deck. So we got rid of that. We got rid of the fact that we were proposing a swimming pool. And by the way, it bears repeating that we don't need any setback relief from any residential neighbor for any of the variances we're looking for. You must remember what the state has enabled you to do. You are a board that gives relief. It's not up to you to enforce the zoning ordinance. It's not up to you to enforce the master plan. It's your function is to give relief. Without that power, this zoning ordinance and the zoning ordinance of any other municipality in this state would probably be deemed unconstitutional. So you're the relief valve, and that's what we're here. We're not the enemy. We're not some criminal. We're here looking for relief. We're following the law by coming to you and asking you for it. The only other thing I want to say at this point is that a question of precedent has been raised. And I believe my client would want to say a few words about what she considers important to her, and the fact that this application started out, there were many concerns about the garage and the storage/pool house aspect of it. We heard those concerns. Periodically, we amended and modified the proposal to address all of those concerns. And in fact, the size of the garage was reduced during the course of all of those proceedings. So from our perspective, that was the big one. That's the thing we heard the most concern about. And so that's one of the reasons why when we came to you within the last month or so, if we had to give up one of the variances, my client, I think, was willing to give that one up because it seemed to be the one that was causing the most of a problem to you. There were some comments along the way about the hot tub, which went from a swimming pool to a hot tub. And they appeared mainly to have to do with the location of it and the fact that it was in the middle of the yard and why couldn't it be closer to the house and could it be screened? And all of those things were addressed. So when we heard that the board's emphasis may have been shifting, that came as a bit of a surprise. Now, as you may know, in the past, and I've been at this probably longer now than anybody else in terms of appearing before this board, and my history with this board has always been to try to work with the board and to come up with a compromise that works for everybody. And that has historically been the way that this board has operated, and we certainly hope that we continue to be in that spirit. And for example, one case I can mention, which is the one that I submitted another copy of, the case on 70 South Hill Street, where comments were actually made that the board worked with the applicant who originally wanted a pool and who decided after some back and forth with the board to go with a hot tub, which, by the way, turned out to be the exact same size as this hot tub. And in that case, it was even so-called worse because the setback requirement was 70 feet, whereas in this case, this requirement is 60 feet. So I think, as far as precedent is concerned, there is already precedent for this kind of application. We've submitted ample evidence of what the neighborhood is like, the fact there were swimming pools, hot tubs, and so forth. And the fact that this request does not require any setback relief from any neighbor and will be totally screened to the nth degree, we fail to see a problem with that. In fact, none was really voiced except for the location. So I would ask you to take all of this into consideration, and I appreciate your time and for having listened to me. But I think it's important that you remember what the state has enabled you as a board to do. And I would like to give my client the opportunity to say something because I know she's very anxious to do that, and so I'd like to let her do that.
Gil, before we hear from Rosemary, can I ask you this question? We have been deliberating for a long time, the amount of relief that the board feels comfortable providing. And then the question has come up recently in our deliberations, whether the applicant would be agreeable to the variances detailed in 1, 2, and 4 of your letter dated January 29th, but not variance in number 3, which is the spa. Is that something you are considering or would be willing to do, or where do you guys stand on that?
As I mentioned before, when the subject of the number of variances came up, my client's initial reaction, which I previously relayed to you, was that she would be willing to give up the garage. I know the hot tub is very important to her, and I'd like to have her have the opportunity to let you know why it is, and then we can proceed further. But I'm glad we're having a dialogue. So with your permission, I would ask Rosemary if she has any comments.
Sure.
I'll go ahead and let her in. Okay, Rosemary, I just need you to unmute yourself and turn your camera on, please.
Okay, I'm unmuted. Can you hear me?
Yes, we hear you.
Okay. So what I want to say is that, Mark, you asked that I prioritize my variances, which I have. And actually, the most important variance to me is the hot tub.
Not now. Later on, thank you.
Can you hear me?
Yes.
Okay, so you did ask about the variances being prioritized, and this is my opportunity to say to you that the hot tub is the most important variance to me. Number two is the front entry. It's a safety issue about that front entry. I actually had a guest who had to go to the hospital, and they couldn't even get into the house with a stretcher. They had to carry her out and put her on the stretcher because the front door is literally 1.5 inches from the bottom step of the staircase that goes to the second floor. That is why I'm asking for that front entry. It's not to get out of the rain. The rear extension would be my third variance of importance. And then the last is the garage storage building. All of your complaints were about the garage. We've been listening to you for 1.5 years now, following all of your advice and your opinions and making changes to appease the board and just trying to come to an agreement about this. So because your complaints were mainly about the garage and it looking like a living space and it having a bathroom, and so we chose that it was the a large variance in size, square footage, to get rid of that variance. I'd be very willing to get rid of that variance and still give up my multifamily status for that.
Rosemary, yes, I appreciate, your time and attention, to our concerns. I think that one thing I should clarify is that our concern was that the garage did not appear to the board actually to be a garage. It seemed like much more than a garage, so we did need to discuss that more than we frankly wanted to. The board is inclined to think that the garage, on balance, is acceptable. The question here would be that in the spirit of moving forward, are you willing to relinquish the request for the spa and receive
Why do I need to relinquish the request for the spa? Why?
Well, it's really a question. You don't,
But why? There's a spa across the street. There's a pool on Walnut Street. There are 19 pools within a 500-foot radius of my house.
Mm-hmm.
It is not within the character of the neighborhood. It's a spa. I'm not having pool parties. It's a water feature that's really important to me for my quality of life. This is my home. I would like to have a water feature. I'm resolved to the fact that you don't want me to have a pool, but it's a spa. It's an 8 by 10 foot spa. You granted a spa to 70 South Hill Street, an 8 by 10 foot spa. They had 70-foot setbacks on a corner. And that was recent. That was 3 years ago. And you defended that in February of 2020, when the applicant wanted to take out the spa and put in a swimming pool. And you said, we gave you a spa, we worked with you, we were showing you that we wanted to work with you and give you the water element that you want. You did that for that applicant. Why can't you do it for me? There's a spa across the street on Pine Street, right directly across the street from me. There are several pools on Cameron Street. There's a pool on Walnut Street, a large pool right across the street from me. What is it about my corner, my property, that makes you not want to grant me a spa?
Well, there are.
I feel like I'm being singled out, like I am being treated differently.
Well, I wouldn't say it's personal, Rosemary. It's not you that's being treated differently, but your property is different from the other properties that you're highlighting for the board.
Not 70 South Hill Street. What's different about that? It's 0.2 of an acre, a little over 8,000 square feet on a corner with 70-foot setbacks, minus 60 feet. Nobody will see this little spa in the ground. It's not going to be up up on a deck overlooking anybody's property. It's in the ground. My property is completely screened in with 15-foot arborvitaes, a wall of arborvitaes all the way around the entire apartment, the entire property. And I will further screen the hot tub so that you won't even see it when you're on the property. Why is this such a problem for the board? I don't understand. What is this doing to the neighborhood that you are so against it?
So Mark, I'm not against the hot tub. You know, I don't know about all the other board members. I don't know what the breakout was.
Mhm.
But she gave up the garage. The hot tub is a small water, like she said, water feature. The
Mhm.
front porch, I think that just to have a roof over the front porch, even for snow and ice, is a safety feature. If John Whoops wants a front porch now, I'll give him a front porch.
Mhm.
But and a little and then the other addition is just a backyard addition. So by giving up the garage, that was sort of the elephant in the room.
Mhm. Okay.
I mean, I know you were concerned that it looked like a pool house. You know, we took out the shower, then we took out the bathroom, then we reduced it, then, so I took out the whole, get rid of the garage, just take the whole thing out.
If I could say something again, you have to ask yourself, what is the harm? And that's, I go back to that balancing test, that state law requirement, an 80 square foot hot tub that's recessed, doubly screened, doesn't need any relief from any neighbors. I mean, that seems to me, I have a hard time finding any detriment to the neighborhood whatsoever.
I mean,
Then
back in, excuse me if I just may say something, back in October, Susan, you weren't against the hot tub. You even said you had a hot tub and that, you were just really concerned about the location of it, that it seemed like it was out in the middle of the yard. And then, thinking about that, it was like, yeah, you know what? It does kind of seem like it's out in the middle of the yard. Let's move it closer to the house. Let's make it part of the house rather than all the way out there in the middle of the yard.
Rosemary, we understand your position. We understand your council's position. So we'll deliberate our balancing, some more. You've answered the question. It was a question whether or not you would relinquish the spa hot tub, and you answered it.
Mark,
We're
we would-
also, can I
multifamily.
just say that this is meant to be our work session. We're meant to have the opportunity to think about these issues out loud. We were good, Mr. Flanagan, you were good enough to send us a 5-page letter that clearly outlined from the very beginning to now how you have perceived the board's interactions with this. Most of that has been repeated today. But what and through the work sessions, our interests have shifted partly based on testimony, but also because of neighbors' concerns, but also based on experience in all of that. And we've gotten a lot of information about this case, but I think that we should actually take it to the public hearing rather than have the public hearing while we're sitting here tonight.
Okay.
I agree with that, by the way. I think we'd be happy to revisit this next week.
Yeah, I
I
mean,
thank-
this
I
has
thank
just
you for
gone
the
on a really long
Been able to
time.
speak
And
here. I
we
thank
had
you
a
for the
lot of
opportunity to listen
information.
to us.
Sure. No, thank you.
Yeah, thank you. And
I'm sorry, that was me. I clicked too soon. Sorry about that, Rosemary. Okay, and you want me to take Mr. Flanagan out as well? Yes?
I think,
Yeah,
Bill,
I'm done.
you're finished, I think,
Yeah, until next week.
until next week.
Okay, thank you.
Okay, so we can move on to our next case.
Mark, could I just say something? I
Sure.
feel like I agree with Julia that this is supposed to be a work session. We have people scolding us and confronting us. That is not acceptable to me. We can't talk. I'm out. I find this to be totally unproductive, the way things are going. Something's got to give.
I was hoping for a resolution, but it
Mhm.
didn't happen.
Okay, I just feel like I don't want to be scolded at the work. This is where we're supposed to be able to discuss things. And I feel like we've got lawyers barking at us, and that really isn't the way I had a different format when I worked on the ARB, but in a way I feel like then let's just be on the record if this is how it's going to roll. Because it really, I think it squashes the discussion as opposed to promoting it the way things were going tonight.
We've discussed
Okay.
this one to death already. I'm ready to
Okay,
vote.
so-
Yeah,
what-
I think the work sessions are starting to turn into a little bit of a regular meeting rather than a work session.
Yeah, exactly. And part of that may be, because they're televised, and we're having it as a Zoom meeting, whereas I remember we used to have work sessions where nobody but the board members were interested. And we did have an opportunity to speak and deliberate openly.
So.
But anyway, let's move on to case number 3096, which is Andrew Spreitzer. I hope I pronounced that correctly, 85 Eldridge Street.
Honestly, I feel like we're in the same thing with this particular case in that clearly the conversation where we're asking for plans that have very specific detail on it, we're not getting them. I mean, Dan, did you feel that what was submitted, did that suffice for you?
No, they needed a better survey with the clearly delineating all the information. We didn't get that.
Right.
Isn't that what, because I said, I don't know what is exactly in actual feet and inches that you're talking about. Last time, could you write it down? And then we needed another survey. And that just, nothing appeared except the same thing over again, it seems to me. I can't make heads nor tails of it.
We have the
Head
site
nor
plan-
tails.
we have the
Say-
site plan certified by the architect. According to Gil, that's usually been good enough.
Mhm.
Whether it-
But they didn't give us, it's not intelligible. It's a,
No, we don't have anything certified by an architect in the case of 85 Hildreth.
No, I'm talking about 71 Walnut.
oh.
No, we moved on to 85, I'm sorry, we moved on to 85 Hildreth Street.
Something in today's package.
I'm sorry?
Isn't there something in today's package?
Yes, there's a marked up survey, but don't we usually in these cases receive, and Dan, let me know if this isn't completely correct. Don't we usually receive construction drawings or architectural drawings to see what's planned by the applicant?
Yeah, usually you do. They will have, preliminary drawings. In this case, there's a small little front porch that encroaches by a couple of feet that they need a variance for. There's a garage that they want 5 feet that I don't even know if they need a variance for now. And then there was that shed on the side of the property. It's a pretty simple case, but the applicant, they didn't get a lawyer. They're trying to do it themselves. Maybe it's an economical reason. So she's having a hard time to presenting clearly her request, So, I mean, I understand it. I think what she wants for the porch is not a big deal. It's an open front porch. It's not living space. It's you know, it just gives them a little outside sitting space in the front of their house on a small lot, you know, so.
I agree with you. I'm fine with the porch, but need a survey delineating exactly, you know, how much of a variance is being granted. With respect to the garage, do you have an understanding as to why they want to expand the garage?
They're for storage. They're taking away the shed. They're giving up the shed. So they need somewhere for storage.
Well, aren't they keeping one shed and giving up the second?
They're giving up one of them at least.
I thought they might be giving up both, but then my question is, so that's pure storage, what's inside there, and wouldn't we want to see interior plans?
Was there living space once? Was this where there was a bedroom that went in the connection to the garage? Yes?
Yeah, that's what I'm asking about. The survey shows bedroom and closet.
And do we have a CO on that?
I know from the building department that a new C of O was issued, but they haven't sent over to the board what is contained on the C of O. But we will get that prior to the public hearing.
So that was the C of O issued before it was sold, before they bought it? Is that what we're discussing?
It was issued in October of 2020.
Did they buy, I think they bought this recently. I don't know why I think that, but I do.
I'm just curious to know if that room inside the garage has been building a permit, has been CO'd, and is it legal? You know, so, I mean, I just want to know that, you know, and then I don't care about the 5 feet on the garage, if they need extra storage for bikes or, you know, lawn furniture, whatever they have. 5 feet's just not much, you know?
But isn't the whole, like we don't need a Vitas Cariolitis situation because it's a bedroom and they left the car running, right? That's a possibility, honestly. I've left mine running. I don't have a bedroom over there, but isn't that why you get a C of O? Yes, safety, some of it?
No, I mean, if they've converted garage space to living space, that has to go through a permitting and an approval process.
Right.
And without a C of O, we don't know if that somebody just, you know, came along and just stuck a bedroom in the garage and we don't know if it's legal or not. That's what I want to know.
Right.
So I'll make sure that the building department circulates to all of us the certificate of occupancy, so we can all read it. Are there any other comments from any board members?
May I just ask, Mr. Chairman, who would you like to communicate to the applicant? Just my understanding is the board wants an updated certified survey.
Yes, and then the question is whether or not they have floor plans. Is it for storage? Because Kevin said that, but I don't know if that's on the record, that the reason for the expansion is additional storage. It's possible, but I don't have drawings. I would like to see what plans they have for the interior of the space, because that will contribute to our understanding of the benefit to the applicant as opposed to the detriment to the neighborhood. So I would like to understand the benefit to the applicant better. And if you could reach out and have the contact information, they don't have counsel for Mr. Spritzer, that would be fantastic.
I'll be happy to reach out.
Are there more comments from the board on 85 Hildreth, or should we move on to our new case?
Let's move on.
We're good. Dan, you're good?
I'm good.
Okay, so our new case is case number 3002, Southampton Ray Partners, 85 Down East Lane. And Chick, do you want to speak to this?
Yes, And again, it is a new case, so I expect we'll hear from the applicant next week. We've had a lot of history with this particular project. We helped with the review of the land division. There has been a restoration on the adjoining property. There was a permit issued on this property, and the applicant came in to make some revisions to the restoration plan. This is actually very unusual because the property is not being developed. It was part of a larger property that had lawn area, turf, fertilized area. And so we were delighted when we got the application to restore this property. And I remain very optimistic that the modifications will result in the elimination of lawn that is fertilized. And you'll notice in the application materials, the applicant provided the original calculations to show how much nitrogen application would be reduced by the restoration of this property. And we're also not having the 300 gallons per day of sanitary waste that a home would generate. But it's very good for Hetty Creek and the Bay. And it continues to be very good for Hetty Creek and the Bay. I do believe that the applicant learned some restoration techniques based on the restoration at 95 Down East Lane. And that in combination with what appears to be perhaps a cost-saving measure, which I don't on the face of it have a problem with, came in with a modified restoration plan. It's still a natural area. It still removes turf. They're using plugs instead of gallon containers for a lot of the materials. Many of the materials, particularly shrubs and trees, are still either gallon or balled and burlapped stock. And my expectation is that it will continue to achieve the benefits that we're looking for in the approved plan. I will tell you that the applicant met with our office in advance of making this application because they recognized that, you know, it was a modification of a permit that was issued. I brought in my landscape ecologist, Rusty Schmidt, who many of you may know. He specializes in this as well as bioswales and restoration planting. And we provided some suggestions on better ways to eliminate the turf and establish a healthy restoration. Those are incorporated into this plan. If you look at the spacing of the plantings that they're proposing with the plugs, they're 12-inch on center. And there's a very high density of a mixed, diverse replanting regime. So I feel this is a good plan. It is, again, we're just receiving the application. I would like the applicant to explain the plan to the zoning board at the next meeting, but my office did have input, and I believe we will achieve the original goals of the restoration, learn from the restoration at 95 Down East, and still achieve all the benefits that were intended by the original permit. So I'm happy if there are any questions.
Can I just check? This is the
Sure.
second lot, not with the house,
That's correct.
that they're selling off? I mean, what is the deal with it? I worked on for the ARB with the house that is enormous. So then when they say they ran out of money, I had to blink because it is a grand and grandiose plan. And I've gone over there to look, but I did wonder why, you know, everyone runs out of money when they get to the drainage.
I guess so.
Landscaping, take it from me. But so I was concerned because they had said they would put in trees and now they're not putting them in. And I don't know. I feel like, is there any give back? What was the deal? Because I wasn't on the ZBA. I was on the ARB, so I had the other side. So I don't know what was the tit for tat, so to speak, about, you know, I did know that property that was just it was a game farm for deer at the end, because with an old house and some geese and 1,000 deer over there, and the lawn went straight down to the water. I do remember that.
Oh, yes. And it flooded. There was an old berm
Oh,
used to retain water. This is on the original property at 95 Down East, because I looked at that as well at the time. So, we can go through a little bit of the history, but 95 Down East was a very large house. It's a large lot. They met the structural setbacks, as I recall. I'd have to pull up the original permit, but that's my recollection, which is why they were able to establish a large house. And the zoning board felt very comfortable with that because, the areas that were within jurisdiction, the lawn was being removed and they were creating a natural wetland buffer and controlling invasive species. So that was subdivided and it stands on its own. And you'll notice on this application, there is no house proposed on this lot. So we have no plans for the development of that lot. We can certainly ask the applicant, but it seems to me as though it's still, effectively being used as part of 95 Down East, but it's not being used for development. And their plan shows 100% restoration. So again, there's no house pending. The original one, my recollection is they conformed to setbacks, removed the lawn, and established a significant natural buffer. And that's what's being done here. And if you look at the plan, particularly sheet L2, there are some trees that are still being proposed. There's 10 black tupelo and 21 swamp white oak, as well as bacchus, which is a shrub in a 5-gallon container. So
but
there's,
on their letter of 1/20/2021, it says tree changes. They reduced the swamp white oak quantity, reduced from 15 to 2. The swamp white oak, all sizes reduced to 3 to 4 inch caliper. I don't know what the original size was. I could look it up. And the orchard fruit trees were eliminated. So, that's substantial.
I have a letter from February 3rd, 2021. And
I
that,
have 1/20/2021 for a letter from Michael Boucher, landscape architect.
just check
That's
that.
February 3rd, InterScience.
Yes. That was their transmittal. Let me just check the Bouchard.
But I believe Mr. Boucher saying this is about this, that the trees are going. I don't know. And then I felt, I don't know if that they actually in the InterScience said that it was not in the public view, but my understanding is that waterfront property does have a public view from the water, which is a really big mistake if somebody's saying that. Yes?
A public view from
The public view, if there's water, is a public view. If you get in a boat,
Sure.
if you go to the beach, those are public views, and they somehow negated that in here. I don't know if I care. I won't be out there in a kayak or anything, but I just thought there were some, I felt like, okay, they got their house, they made that part beautiful, and then all of a sudden, I don't know what the contingency is of the agreement of the previous, I guess that's what I want to know from you. The previous plan that now they've decided to plead poverty, which I thought was unusual but honest, and say, we don't want to do this much, we don't want to spend this much money, so this is what we want to do. Is that correct?
I guess that's part of what they're proposing here. I just want to make sure, I'm looking at a January 21st, 2021 plan, sheet L2.0. I'm sure the applicant can help us and explain. And there's 10 black tupelo and 21 swamp white oak.
Well, what?
Hey,
I'm
Chick,
reading
I
this.
have a question for Chick. When you look at that plan, this is it's an empty lot that they're going to revegetate. And I'm always interested that they're not bringing in species that are not indigenous to that area. Your overview of the plan and the plantings that they want to do on the property, are they consistent with an indigenous growth that wildlife and birds and whatever would, inhabit that property works?
Yes, we checked all the species checkout. We made suggestions. They incorporated our suggestions for native vegetation. So it will include, obviously habitat, bee activity, bird activity, wildlife browsing, and it's beneficial in that sense. It is native.
Chick, is it possible for you to share a screen where you can show before and after?
I will try. There's a lot of materials here, but let me do that. And again, I think it will be useful to hear from the applicant at the right time. So I'm just looking, Susan, is
Yes,
this
the second page.
the second page? I saw that where he talked about some of the changes.
Yeah, tree changes. I thought this guy was pretty straightforward.
And that's interesting to me because that's the day before the plan that I have that I'll go down to. Just bear with me, don't get too dizzy here.
Okay, here we go. No?
Yeah. So I want to get to the date. January 20th is the same day. This is the broad plan, but the next plan, one more, this one, which is dated January 22nd, 2021, this year, has 10 black tupelo and 21 swamp white oak.
My guess is that didn't get taken out of that chart, but maybe Mr. Boucher's thing is more accurate. I don't know.
And maybe I'm misreading something because I see that these are bubbled. And maybe we should rely on his letter, but I was taking this to mean that we still have a pretty good density of tree plantings. So I can look at this in more detail. We can certainly ask questions. And I will.
What do you think about agreeing to put in the trees and then taking most of them away and then putting in things that are 2 inches in diameter? I mean, that's not, I don't consider that much of a tree. I don't know. I'm still trying to figure out what was the deal? What was the, they did both of these plans, right, at the same time? Chick?
They didn't do them at the same time. This one followed later.
Okay, I wasn't on the ZBA then, so I'm a little out of the loop. I knew more from the other side. So, but then when someone comes back, so no one would quibble with the first plan, right?
Right, the board approved that. It was a good restoration plan.
So now you're saying that this is adequate or not?
I'm saying that it still achieves native restoration with native plants. It's a little different strategy. It does control the grasses that are there now, the turf.
Yeah.
And will smother them and allow for new materials to come in. And I may have been misreading the plan and will look for a clarification from the applicant. But it is a native restoration plan that will remove the lawn and provide habitat. So we certainly want clarification on exactly what's being proposed. But Dan's point and what I'm saying is that the species are good and it is all native. There's no grass, no lawn. They're keeping existing natives where they are present. There's a couple of notations here for existing trees to remain. And as I said, I may have been misreading the plans and we'll look at that further.
But go back for the basics, Chick. Why were they proposing this vegetative plan?
Well, I guess to create, I mean, I can't get in their heads, but it in effect was removing lawn and establishing a native planting regime that would benefit wildlife and have good environmental effect.
On a vacant lot.
On a vacant lot, correct.
So this wasn't in any way connected with any variance requests or wetlands relief on the adjoining lot.
That's my recollection. And for the purpose of 85 Down East, it's really just because they have a planting schedule within 125 feet of wetlands. So they need a permit, but there are no structures proposed, no relief sought. It is strictly a native restoration plan.
Huh.
I guess, Jeffrey, we do need the original decision then, or the original, is it a permit then for,
They included that with their application materials. The original permit is there.
and, but that permit had nothing to do with the adjoining property.
It's just, if I don't make you too dizzy again, we can go up to that. So here was the permit for 85 Down East. Let me just enlarge that a little bit. So the description of the action was planting within 125 feet, Phragmites, so invasive species. No upland development is proposed, and nitrogen load calculations were provided that demonstrate that the concentration of nitrogen is less under the proposed plan than the existing conditions. And there was a planting plan that I believe is also part of the application package. That may be here. It's a little different orientation. I'll just double check the dates. This was that same plan, so it's L2. And I don't know if Lisa Poyer is on listening in, but again, at the board's discretion, we can invite the applicant if they have useful information for the work session.
She is on, Chick. She did have her hand up, but she put it back down. So you guys let me know.
Okay, that'll be up to Mark and the board. But this is the 2018 plan. So this was the same sheet L2. This does have a similar pattern of plantings to what we just discussed. Some existing trees to remain. And it does appear as though they have a little different species count. And some of the same grasses that were being established. So I guess if we review that letter that Susan mentioned from the landscape architect dated 1/20, they are removing trees in favor of other plantings that are native and will create kind of a more grassy regime that will ultimately succeed into a woody vegetation just because of the other species in the area, and will provide value of habitat for bees, butterflies, and other wildlife with a different type of restoration. Let's rotate this view. And that was what was identified here. And again, I may have looked at the plan incorrectly where they are removing a lot of these species and reestablishing different ground covers that are also native. It's up to the board if you would like to hear from the applicant, if any further clarification is
No,
needed.
I think it would be helpful to listen to Lisa.
Okay.
Can we let her come in, Antoinette?
I'm getting her right now. Okay, let me see where she is. Okay, Lisa. We just need you to unmute yourself and put the camera on, please. Thank you.
Good evening, members of the board. Lisa Poyer with Inner Science on behalf of the applicant. Just to address a comment from Susan, the letter that's dated 1/20/2021 that discusses the reduction of the swamp white oak, we will correct that. It is proposed to be 10 swamp white oaks. So as shown correctly on the plans.
Okay, that's
There are
21,
more trees.
Lisa, that was 21 swamp white oak and 10 black tupelo.
I just did the numbers here. Yes,
If
10
I'm
black.
looking-
Yep, 10 black tupelo and 21 swamp white oak. So the plans are correct. We will have the letter updated. The letter was what was originally discussed with you, Chick, and it just got missed as far as the update based upon the new plans.
Good. Thank you for the clarification. I'm glad I read the plan correctly.
Yes. And then we can have the landscape architects available at the public hearing to discuss and walk you through all the proposed changes for the wetland buffer.
Lisa, I'm
Yes,
still confused. On the 1/20/2021 from the Boucher Landscape, there were 3 tree changes, right?
yes,
What about the orchard fruit trees eliminated?
yes, they have been eliminated from the plan. They do not appear on the current proposed plans.
And the swamp white oak.
The sizes were reduced in caliper
the
diameter.
number is from 15 to 2.
Right, I said that one needed to be updated. It is going from 15 to 10. I'm sorry, it would be actually that should be updated. We had originally done 10 black tupelo. We're still proposing 10 black tupelo. And we're doing 21 swamp white oak. And we originally proposed 33. So we'll have,
I don't see any, the 21, the 33, I don't know what, I'm not seeing this, but okay.
Susan, that was, if you want to look at the screen and then check your file, that was the plan that I showed before that was L 2.0. This, here's the title block, L 2.0.
Well, I'd like
the original plan that was submitted with the application for the original approval showed 33 swamp white oaks. The new current plan is showing 21. So that number has been reduced.
I was relying upon the summary by Michael.
Right, I said this one was prepared.
Does not correspond to whatever you all are into, so.
That letter is incorrect is what we're,
Okay, I just,
I will have a new corrected letter submitted to the board.
I'm trying to understand it and I'm confused, and rightfully so, evidently. Fine.
I will have a new letter prepared and submitted to the board by the end of this week in time for the actual meeting, as well as the landscape architects will be available at the public hearing to walk you through all the proposed changes.
Well, it's a
Thank you, Lisa.
worthwhile
That'd be great.
discussion so that we caught this now at the work session, so it didn't go to the
Yep.
public hearing with us.
very, very true.
Lisa, do you understand? So what is the point of this? I mean, for the applicant, it's the adjacent.
It's the adjacent property. They want to include it as part of the native landscaping plan that they have done extensively on the other property, which is 95 Down East Lane. And they want to continue it. They wanted to save a little bit in cost of some money here. And so they proposed to go to plugs and to expand some of the grassy areas and to just change the plan around a little bit.
Thank you.
But it is going to be all native vegetation, and Chick has reviewed the species, and we are moving forward with, trying to preserve this as an open space as an extension of the main house property.
Thank you, Lisa. We're going to see you next Thursday as well.
Yep, no problem. Thank you.
Appreciate it. So you know that these come to us and, we're kind of reviewing it here at the work session. I generally use the plans for the purpose of the permits. And the plan appears to have been accurate, but that was a very good observation and it sounds like it will be corrected. And also, I think they understand that we want to understand the difference between the plans. But environmentally, the net result is still a restoration of native vegetation on a vacant lot.
Dick, so it's just the difference in like the time it would take for the plugs to get bigger as opposed to the gallon size?
Yeah, plugs can be very effective. The immature material can grow quite healthily. As I said before, there's a nice diversity of species. There's a very good density of species. And we also have the survival requirements of the village, that this will need to achieve 85% survival over a 3-year period. It has to be monitored yearly.
Oh,
Expect that we'll have a very healthy restoration. You know, whether it's trees, shrubs, or a combination thereof with ground cover, you know, we're achieving multiple habitats with many benefits, as I said, to all kinds of wildlife and reducing the lawn area. So net, it's a great restoration plan still, but we should understand those changes.
thank you.
So I think that's the end of the cases to discuss. Does any board member want to discuss anything else other than cases, or should we just adjourn?
Excuse me, I may just not have gotten an update, but 3099, was that adjourned? I have that on my agenda that I got from the building department.
What is 3099? What's the address?
GN.
1384 Meadow. That was adjourned.
That was adjourned.
Okay, to March, is that correct? Because I did not receive that from the building.
Yes, there's a letter from the applicant's council adjourning it until March.
And the same for Four Fountains, correct?
Yes,
Yes.
definitely.
Yes.
That one we had already.
I have a question. So that the 85 Down East Lane, that's a new application. Am I muted?
No, we can hear you.
Wasn't that supposed to use the new application form?
Not, the March meeting will have the new
Oh,
application.
okay, because it's important. Thank you.
So that's the ball game today, huh?
Okay, so we're going to adjourn for all purposes and see everybody next Thursday night.
Terrific.
Okay, thank you, Kevin. Thank you, Dan.
Have a good night.
Thank
Good
you.
night,
Nice to
everybody.
Thank
see
you, everybody.
everyone.
Thank you, Jeff.